Okay, so I'll get started. So I'm going to be addressing the Dublin 3 regulation and what's called the Section 3 letter, which is a proposal or a notice to deport. So just to give you a brief overview, I've got 6 sections. First of all, I'm going to be placing both of these procedures in the general International Protection Application procedure context. So whereabouts do they come? Then we'll be looking at the Dublin 3 regulation, first of all, in general, then the procedure that attaches to this regulation, and then what criteria substantively apply. And then 2 sections at the end look at the Section 3 letter. So that all sounds maybe a little bit confusing, but I'll get into it and hopefully it will become clearer. Okay, so generally, now I have a paper and hopefully that will be distributed, and it has a nicer colorful image of the procedure. This is just what I could do by myself on a PowerPoint presentation. So first of all, somebody arrives at a country, Ireland, and applies for international protection. So that is colloquially asylum. You apply for asylum. It's just known as international protection legally. You have a preliminary interview. That could be at the airport or it could be at the International Protection Office. If during this preliminary interview it becomes apparent that another member state might be responsible legally for processing the international protection application, what's called a Dublin 3 Article 5 interview will take place. So that doesn't take place all the time in every situation, only when there's some evidence to suggest that that person should be transferred to another member state. So that's the Article 5 interview. Following the Article 5 interview, either a transfer decision will be made or not, and if a transfer decision is made, the person can appeal to the International Protection Appeals Tribunal. So if there's no transfer decision or if there was no Article 5 interview at all, the person has a substantive called a Section 35 asylum interview, and that's a substantive interview to see what forms of persecution they might fear. And then there's a decision, sorry, I missed that. There's a decision on whether or not that person is entitled to protection. That can be appealed to the IPAT. And following a decision of the IPAT, there might be a legal difficulty with the decision and there's potential scope for what's called a judicial review challenge. If all of that is unsuccessful, if the person is unsuccessful and they get a refusal decision after all of that, what's called we'll get to the nuances of this later, but it used to be a Section 3 proposal to deport. Now it's a Section 49 proposal, and you can make representations, and it's a Section 51 proposal to deport, but I'll get to the differences between the two later on. And then a person can make representations as to why they should be allowed to stay in the state, even though they haven't been granted asylum. So looking first at the Dublin 3 regulation, what is it? So in EU law, it was decided that only one member state should be legally responsible to examine the substance of an asylum application. So the Dublin regulation, the purpose is to determine what member state is responsible. So there's a series of criteria that are applied, and they serve to select the responsible member state. The rationale of this was to deter secondary movements of asylum seekers, so movements between member states, and also to avoid the proliferation of decisions on the same application. So if somebody makes an application in, say, France or Greece, they travel to another member state and the same process takes place. They didn't want that for different member states to be looking at the same application. So only one member state should ever look at the substance of an application. Initially, the Dublin well, there was a Dublin Convention and a Dublin 2 regulation. Now there's a Dublin 3 regulation. Initially, they were understood to just be an administrative agreement between member states. So if member states decided between themselves that one member state or another were responsible, that was the end of it. The person themselves, the individual, used not to have any right to contest that. Now, however, they do, and there was a series of cases that decided this. So if a person doesn't think the right criterion was selected or feels that the facts of their case weren't understood correctly, they can challenge that. And just to mention that while the Dublin 3 regulation continues in force, there are proposals to overhaul this system, and that's the proposed Pact on Migration and Asylum. There's discussions on the fine details of how that is to come to fruition, but that's ongoing. But just to let you know. Okay, so the procedure. How does what happens when the Dublin 3 regulation is initiated? So again, there must be some evidence that a person their application should be examined in another member state. So either they give details of their travel history or they give details of their family background, and there's something to suggest that they should really be in another member state. That leads to the Article 5 interview. The Article 5 interview, the sole purpose, and they're often quite short, the sole purpose is to determine which member state is responsible. So the person attends at the interview and they're asked questions in respect of the criteria, and we'll get to that, of the Dublin 3 regulation, such as their family background and such as how they travelled to the state. Following the Article 5 interview, if another member state is deemed to be responsible, Ireland will issue, or another member state to Ireland, will issue what's called either a take charge or take back request. So a take charge request is where the other member state has never processed any part of the application to date, and a take back request is when they have, and you're just asking them to take back the person. The initial request to take charge or take back must be made within 3 months, or 2 months if it's based on a Eurodac hit. And a Eurodac hit is a hit from a database of fingerprints. So if the person in question has been in another member state and has had their fingerprint taken, that will go into a central database, and other member states might get that hit later on. The other member state must reply within 1 month or 2 weeks if based on a Eurodac hit. And failing, if those timelines aren't complied with, the member state who has failed to comply with them is deemed to have accepted the case. So in the case of the initial application, if that the initial take charge or take back request, if that's not done within the 3 months or the 2 months, the initial requesting member state is out of time. So they have to continue to examine the substance of the application. And if the requesting member state doesn't comply with the time limits, they are deemed to have accepted. So the transfer will take place. Once all the information is gathered, so the Article 5 interview and the response to the take charge or take back request, a transfers decision is made, and it sets out all the reasons why the IPO believes that another member state is the responsible member state, and the transfer decision decides that the person is to be transferred to that member state. The person can appeal that decision within 15 days. And they can raise either issues of fact or law in that appeal. So once an appeal has been lodged, the person is entitled to remain in the state until the appeal is fully processed. After all of that, the transfer, so after a final decision either on appeal or a final decision after a judicial review, if that has taken place, if there's a legal difficulty, the transfer decision must take place within 6 months of either of those, or 1 year if the person is in prison, or 18 months if they have absconded. So if they have, if they haven't resided, say if they're required to reside at a certain location and they haven't done so, or they haven't informed the IPO or the minister of their updated address, then they're deemed to have absconded. So that's important to make sure that you update any changes of address to the minister, because if the 6 months expires, Ireland must examine the application, but if you haven't updated the minister with your address, it goes to 18 months, which is obviously significantly longer. And then if at the end of that a person is transferred erroneously, Ireland has an obligation to promptly accept that person back. So getting that then to the substantive criteria. So once an applicant makes an application for protection on the territory of any member state, that member state is obliged to do one of either of two things. Either they have to process the protection application in full, in substance, or they must transfer that person to another member state to do so. They are not permitted to deport a person prior to the finalisation of either of those two processes. So if a person arrives in Ireland and claims asylum, that application, the process of that application must be completed before they can be removed from the state. So say at the airport, if a person makes an application for asylum, they must not be removed from the state until that is processed. And that's important because sometimes there's no legal representation at the airport. And sometimes there can be, return flights availed of. That is not legal. That is not in keeping with Ireland's legal duties. They must examine the application in full. So what are the criteria in substance that attach to this Dublin 3 regulation? So there's a few special criteria. So the default member state, if all the other criteria are looked at and none of them apply, the default member state is where the application, the asylum application was first lodged. So that's the default position. Where a person for any number of reasons cannot be transferred, the determining member state must process. So that would be Ireland in the event that that person is here present in Ireland. So if they can't be transferred, Ireland needs to examine the full substance of their asylum application. Where there is a risk of inhuman or degrading treatment in another member state, so say in Ireland, if it is believed, and this happened, maybe you might have heard of the Greek transfer cases. So Greece was inundated with applications and their system simply couldn't cope with the number of applications. So if Ireland had an application from a person who had travelled from Greece, it was found that there was a risk of inhuman or degrading treatment in another member state, in Greece, so they couldn't be transferred to Greece. But that doesn't necessarily mean that Ireland's responsible. They simply must continue to apply other criteria to see if another member state might be responsible. I'm just looking at my slide there. I'm wondering whether hold on, just no, actually, maybe I shouldn't. Actually, wait, I'll just, because I might, hold on. Oh, yeah, I just think that I might have missed, I think I tried to fit too many things onto that slide and we might be missing one bullet point at the end, but we're not. No, it's fine. Sorry about that. Okay, back to this. So yeah, they are the special criteria. There's also, two more special criteria. So member states are permitted the Dublin 3 regulation only applies to other EU member states, as in they can only be transferred in accordance with the regulation to another EU member state. But a safe third country is a safe country outside of the EU, so another country outside the EU. Member states are permitted to send a person to a safe third country in certain circumstances, and these are that, and there's a list of different criteria, but briefly, these are when that third country has minimum human rights standards. So you can't be, or there can't be a risk that that person would be exposed to persecution in that country. Also, there must be evidence that there is a connection between the applicant and the third country concerned, on the basis of which it would be reasonable for that person to go to that country. So that's quite broad. So it might be that you have some kind of permission to be there, or a visa, or family members there. It's just you have some connection and it would be reasonable. So that's quite broad. I haven't seen that applied in many cases, but it is a possibility. And another special criterion is in respect of children. So their best interests must be a primary consideration. For example, where there are family reunification possibilities, they should be considered. The well-being and social development of the child must be considered. The risk of human trafficking must be considered, and the views of the minor, in accordance with their maturity, must also be considered. When the criteria in the Dublin 3 regulation are being considered, it's the factual position when the protection application was first lodged. So if that factual position changes, that doesn't affect the application of the criteria, and also it's not when the person initially moved. So it's only when sorry, again, my screen just went. Oh, hold on. Sorry, I'll be back in 2 seconds. Okay. So yeah, the factual position when the protection application was first lodged. In respect of dependent persons, so they are defined in the Dublin 3 regulation, and I have the definition here somewhere. Hold on. Oh yeah, so where on account of pregnancy, a newborn child, serious illness, severe disability, or old age, an applicant is dependent on the assistance of his or her child, and vice versa. So they are what is considered to be a dependent person. So where there is a dependent person, the member states shall normally try to keep or bring together the dependent person and those on which they are dependent, provided the ties existed in the country of origin. So it can't be a new circumstance of dependency. There must have been dependency in the country of origin. And the final special criterion is the discretionary clause. That's Article 17. And there was a lot of litigation concerning this clause in recent years. The difficulty was that while the International Protection Appeals Tribunal had jurisdiction to consider all of the other criteria, it wasn't clear whether the IPAT had the jurisdiction to examine this discretionary clause, or whether it was a sovereignty clause and only a minister of the government could decide to apply this clause. So that went all the way to the Supreme Court and went to the Court of Justice of the EU, and ultimately it was found that the IPAT does not have jurisdiction. So a separate, so the discretion clause is very, very broad. It's humanitarian considerations and there hasn't been an official pronouncement on what the possible criteria are, but I'm just supposing that it might be such issues as if a person has mental health difficulties, if there has been significant delay in the examination of their application. If they are attending counselling for whatever reason in this state, they might be humanitarian reasons that might be considered. But the IPAT can't consider these, so there would have to be a letter sent to the Minister directly, the Minister for Justice, to submit that these humanitarian considerations exist. I understand that the Minister might be bringing into operation an official procedure, but I'm not aware of whether that's in place as of yet. So they are all the special criteria. These are the normal criteria, so to speak, and there's a hierarchy of criteria. So that means that the first criteria on Article 8 there must be applied first. If that doesn't apply to the case or the facts of a certain case, then Article 9 is looked at. If that doesn't apply, then Article 10 is looked at. So there's a strict chronology, a hierarchy, and they must be applied in that order. So the first one is minors, and these are unaccompanied minors. So the rule is that if the unaccompanied minor has a family member or a sibling in another member state, that member state is responsible, provided that it's in the best interests of the child. So family member here is father, mother, or another adult responsible for the applicant, whether by law or by practice of the member state where the adult is present, or a sibling, and that's a sibling. Where an unaccompanied minor has a relative, and that's defined in slightly broader terms, that's an adult aunt or uncle or grandparent who is legally present in another member state, and where it's established based on an individual examination that the relative can take care of that unaccompanied minor, well then it's that member state, provided that it's in the best interests of the minor. And in the absence of a family member in respect of an unaccompanied minor, the responsible member state is where they lodged their application for international protection. So that's in respect of an unaccompanied minor. Then you move on to family. So there's 3 family members and they must be applied in order. So first, are there family members in another member state who are beneficiaries already of international protection? In that instance, it is that member state where the family member is present and has been allowed to reside as a beneficiary of international protection. That's provided the persons concerned have expressed their desire in writing. So it would be necessary to have the family member and the applicant express their desire to be reunited in writing. Then Article 10, family members who are applicants, so not yet beneficiaries. So they don't yet have a first instance decision, but they've applied for protection, but it hasn't been determined yet. In that instance, that member state is the responsible member state. So where there are a number of family members who are still where they are at the stage before a first decision, they should be reunited in the member state where the family member has already applied. And then there's a family procedure, and that's Article 11. Sorry, these are all in my paper, so if it's getting a little bit confusing, the criteria are quite detailed, but it might be of assistance to you to hear this from me, and then you can look at my paper if you need further details or ask me later. So the family procedure, that involves a situation where there are several family members who submit applications for international protection in the same member state simultaneously, or dates sufficiently close in time. In that instance, the procedure for determining the member state responsible, must be determined on the basis of the following provisions. So where the member state responsible is where the largest number of them are present. If there are equal numbers in different member states, the responsible member state is where the oldest family member is present. So that's where there's groups of families. Then Article 12, that's the next criterion that needs to be considered. This is where a person has been issued a valid residence document. So where they've been issued a valid residence document, the member state that issued that document is responsible. Equally, where they have been issued a valid visa, it is that member state, the member state that has issued the visa, that is responsible. And this is subject to certain provisos. So where there are more than one valid visas or residence documents issued, it is the member state that has issued the residence document or visa with the longest period of validity or the latest expiry date if they're both equal. So, and then also it's only that this criterion only applies until or for such time as the applicant remains in the territory of the EU. So if they have been issued a visa or a residence document and then leave the EU, this this criterion no longer applies. It's no longer relevant. If they were issued a residence document which expired more than 2 years previously, or a visa which expired more than 6 months previously, that this criterion no longer applies as well. So then Article 13, this is entry and or stay, and this concerns irregular crossing of a border by land, sea or air from a third country. And in that instance, it is the member state thus entered that is responsible. And this responsibility ceases 12 months after the date of the irregular crossing. This is so if it cannot be established that the person crossed a border irregularly, if it's suspected but it can't be established, the responsible member state is the member state in which that person has continued for a period of at least 5 months. And if the person has resided for at least 5 months in several member states, it is the member state of all of those in which that person has resided the most recently. I hope you're all staying awake for this. Sorry, it's very detailed. I'm getting to the end of the criteria and then you can ask questions at the end. So 14, visa waived entry. So if a member state has allowed entry to a person on a visa waived basis in that they didn't need a visa to enter, that is the member state responsible. Where that has happened in 2 or more member states, it's the most recent member state in which they travelled through. And finally, where an application is made in an international transit area or of an airport, that member state becomes responsible. Okay, so that is the Dublin regulation broadly. Again, ask questions at the end if you would like. So I'll just move on then to the Section 3 letter. So the Section 3 letter, there's a difference between
Sorry if I could interrupt you there. I think there are people that are waiting in the lobby. Just in case if people are waiting in the lobby, could you just admit them, please?
Oh, do I need to do that?
Yeah, because you're in control.
Okay, so how do I do that?
I think it will pop up on your end.
Okay.
Yeah. So if that just happens, you just press admit.
Sure. Okay,
Thanks.
great. I will admit people. Yeah. I haven't seen that now here though. Oh, another user took control. Ah.
I don't know how that happened. I didn't take control myself, so I think you might need to share the slides again.
Okay. 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 How do I get rid of this? Sorry, I'm just not very tech savvy. It seems to have gotten a bit grid view. Do I want grid view? How do I get rid of these underneath? Does anybody know? Or do you see that? Do you see a line of pages underneath it?
No, we can only see the slide that says Section 3 letter procedure.
Okay, cool. Okay, well, it's just a bit small for me, but that's fine. Okay, so the Section 3 letter. So initially, Section 3 of the Immigration Act 1999 applied to all deportation orders. So that's where the Section 3 letter comes from. In 2015, the asylum process was amended, and now after the asylum process, a deportation order issues under Section 51 of the International Protection Act 2015. In that instance, if a person has gone through the whole asylum process, a deportation order is automatic, because as part of that asylum process, a person is given the opportunity to make representations, and that's called a decision is issued under permission to remain under that act, called the Section 49 decision. So that act is slightly different. So if a person, say, is refused an immigration permission, any other immigration permission other than asylum, so say a visa permission or a work permit permission, or if they're just here legally, any of those instances other than asylum, the Section 3 process still applies. So when the person no longer has a right to remain in Ireland, a Section 3 letter will issue to them. It may happen immediately, it may not happen for years, but this has to issue before a deportation order issues. So what the Section 3 proposal to deport comprises is it gives the individual three options. They are, first, to return to their country of origin or country of nationality voluntarily. This would mean that no deportation order would issue. They would return voluntarily, and the advantage of this is that they can come back voluntarily if they have a valid permission in the future. A deportation order means that there's a permanent exclusion of that person from the state unless that deportation is revoked, and it's permanent. So the person would have to apply to have it revoked and then make an application for permission. So that can be complicated. So there can be advantages to returning voluntarily if that's possible. The second option is to consent to a deportation order being made. That's not very attractive because, as I said, that's a permanent exclusion from the state. But the only advantage there, or maybe I think you can get help returning if a deportation order is issued, so that might be advantageous as well. One advantage of that option is that the deportation order must be executed within 3 months, and if it isn't, then it expires. So I suppose that's a game of poker there. If you're chancing that the state won't be able to return you, say during COVID, they might have been able to return you during 3 months. That might have been an ideal situation to chance that. But they can just issue a new proposal to deport. So, but I think there would be grounds if if they allowed that to expire and they issued a new proposal to deport, I think there would be strong grounds to say, look, that's really an abusive process on your part, state, and you must really consider whether or not there are good grounds on which to grant that person permission to remain. Finally, the third option is that a person can make representations on why they should be permitted leave to remain or permission to remain. Those representations must be made within 15 days of the letter proposing to deport. So what would a person include in this, the Section 3 representations for permission to remain? So why that person shouldn't be deported. So Section 3 itself of the 1999 Act sets out a number of considerations that the Minister must take into account in determining whether or not to grant a person permission to remain. So these are the age of the person, the duration of residence in the state of the person, their family and domestic circumstances, the nature of their connection to the state, their employment, including self-employment record, their employment, including self-employment prospects going forward, the character and conduct of the person, both within and outside the state, humanitarian considerations, any representations duly made on behalf of the person, the common good, and considerations of national security and public policy so far as they appear or are known to the Minister. So in setting out the representations addressing all of these, and they should all be addressed to some extent, even if they don't really apply, a strong letter setting out representations on why a person should be permitted permission or should be allowed permission to remain. A strong one, it sets out all of these criteria in as much detail as possible. Really, if not much effort is being made to set these out in as much detail as possible, that's a weaker representation, and the stronger representations are more detailed, are more strenuous. Really, this is the last option or the last chance that person has to be given permission to remain. So really, all efforts should be made to make it as detailed as possible and as strong as possible. So all of those criteria should be addressed. Also, two further considerations should be addressed as well. So these are, first of all, family and private life rights, both under the Constitution and under Article 8 of the European Convention on Human Rights. So these are family links in the state, and if a person doesn't have family in the state, private life links. So they're links to the community, to their employment, to their fellow employees, if they're members of any community groups or religious groups, and also it's really strong if a person can get letters of support or reference letters to say that they have good character, that they're working good in the community, or these are really strong. Any reference letters like that should be dated, the contact details should be written on them, and signed by the referee, the person who is making representations on behalf of the person who is subject to a proposal to deport. And then finally, prohibition of refoulement also should be addressed if applicable. So this would be, say, in the instance that either no asylum process has been or has taken place, or at the end of the asylum process, say if something happens in the person's country of origin that changes fundamentally the position, a war breaks out or something to that effect, and all of a sudden, yes, they are subject or at risk of persecution. This should be addressed in full, in as much detail as possible, if it's applicable, country, I say COI, that's country of origin information. So documents from Human Rights Watch, from Amnesty International, to support the claim that there are serious issues in the country of origin. Now, general documents like that aren't sufficient. They should also, you should also, or the person should also address how they relate to them. So how are they a member of a group that is being persecuted? Are they a member, and how they need to prove this? So they need to submit documentation to show that they're either a member of a religious group that are being persecuted, or else the war is so bad that they would be at risk, even they would be at serious risk by reason of their presence in that state. So I'm just admitting somebody else there. So that's really what I wanted to address. That's a real overview of both the Dublin 3 regulation and what should be set out in representations to counter any proposal to deport, as to why a person shouldn't be deported. So thank you very much for listening, and please don't hesitate to ask any questions if you have them. So I'll send the camera back to you, Kuda.
Thank you so much, Dr. Ifer. So before we go into the question and answer session, I'll just quickly run through the options that are available within IOM. And this would be option, of course, before someone receives a deportation order. And I just want to mention, I think most of our participants as well are having challenges in logging on this evening. I don't know what's happening. I'm just getting a number of emails and text messages. So I'll just quickly open my slides and go through what we offer within the organization itself. I'm not sure if everyone can see my slides.
Yeah, I can.
So what I'll just quickly run through is just a brief background of what IOM is, what it does to those that are not familiar, and the options that are available to migrants prior receiving a deportation order. So IOM stands for the International Organization for Migration, and it became part of the United Nations in 2016 after being established in 1951. In terms of what it does, the main purpose that IOM serves is to ensure effective, orderly, and human migration, and it remains the leading international organization in the field of migration. In terms of the programs available within the organization, we have assisted voluntary return and reintegration, which is interlinked to today's session and which I'll talk about in depth in a few minutes. We also have the resettlement program, counter trafficking, protection for vulnerable groups, integration, and family reunification. So in terms of the assisted voluntary return and reintegration, it is the main program which is linked to other support programs. And this program, assisted voluntary return, can be availed for by those seeking to return to their countries of origin on a voluntary basis. The program is open to asylum seekers or international protection applicants, irregular migrants, victims of trafficking, and unaccompanied minors from non-EU countries wishing to return to their countries of origin, but do not have the financial means and/or necessary documentation to do so. Given that the program is voluntary, it means it is readily available. It is a readily available option to migrants who do not find Ireland as a viable option anymore. Someone could be facing challenges in Ireland for one reason or the other, and they don't find Ireland viable anymore, or they might have family members who are facing challenges back in their country of origin, and they might want to go back and be with their family members to support them. So I'll just quickly go into detail about what assisted voluntary return is and what the application process entails. So first of all, if an individual is an international protection applicant, we will be asking this beneficiary to seek legal advice from their solicitor before they withdraw their application with the International Protection Office. After they get legal advice, then we can proceed with sending them application forms which they need to fill out. This is where we need to obtain what is called written consent. Our services are voluntary. Assistant voluntary return is voluntary, so we need to obtain written consent from the beneficiary before we can go ahead and process their application. And we also need to gather relevant details such as your name, date of birth, any health conditions that we need to be aware of, and any other relevant details and surrounding circumstances which might affect your application. And we would also want to understand details such as where you are originally from or where you are returning to, because some countries we will not be able to, because of maybe human rights reasons, we might not be able to assist with people returning back to that country of origin. So it is important for us to obtain as much information as possible. And once your application has been completed, received in our offices, and reviewed, you are allocated what is called a caseworker. And the caseworker is that member of staff that you'll be working with throughout your application. For example, if you need to understand anything about the process itself, if you need to understand about the duration of processing your application, they will be up to speed with all this information. And if you have any healthy needs, they will have to engage with the relevant professionals to try and get you assistance while your application is being processed. And this might include some people might have maybe, for example, sugar diabetes or hypertension or mental health issues that might need to be attended to. So whilst your application is being processed, you might be put in contact with internal support services or external support services such as therapists or counselors or medical professionals that might need to assist you with that particular issue that you might have surrounding circumstances. And whilst the application is still being processed as well, we will also be able to put you in contact with our colleagues in different missions. I might ask Rebecca to just quickly step into this and maybe just quickly go through the virtual counseling in just 3 sentences of what virtual counseling entails. Rebecca, in just a few lines.
Hi, everyone. So thank you, Kuda, for providing the presentation so far, and also to Aoife. It was really interesting, so thank you. In terms of virtual counselling is offered to migrants in Ireland, whether they are in the asylum system or they are undocumented in Ireland, and they are looking to return and determine their reintegration options upon arrival. So virtual counselling, in a nutshell, is an online appointment which is free, voluntary, and confidential, whereby beneficiaries can ask questions to a virtual counsellor who is an IOM staff member who is based in the country of origin. And they can ask any questions that they have on their reintegration, their return journey, and any hesitations or concerns that they may have. So that's what virtual counselling is. And if you're interested, please contact myself or Kuda with the details provided earlier. So Kuda, let me know if you want any more information on that, and I'd be happy to send that through.
Thanks, Rebecca. That was well explained. And just to add on to that as well, the main reason we have introduced virtual counseling is because we want to ensure that beneficiaries are well informed with their decision making. We do understand that colleagues in their country of origin will have first-hand information on the situation on the ground. So once you pass the virtual counseling stage, then it goes to authorization. Once the application is authorized, you receive a grant, and the grant will not be given in cash. It's given in different stages, and this grant goes towards maybe upskilling if you're looking to start up a business, or you're looking to upskill yourself in a certain area, or you're looking to go back to education, or maybe acquire skills that will assist you to be self-employed or start up a particular business as well. And your travel expenses will be catered for once the application is granted, and the travel expenses will actually be the travel ticket. And what would be the limits for availing assisted voluntary return? There are actually limits, and the limits are related to when someone is issued with a deportation order. Once you are issued with a deportation order, we become quite limited in the capacity that we can work within, and we cannot intervene when a deportation order is served. In that regard, we always encourage migrants to weigh all possible options available to them to validate their immigration status earlier within their migration journey by seeking timely and appropriate legal advice. What other options that are available within our IOM? There are also options available within IOM. We have the family reunification, which is one of the most important aspects of safe, orderly, and regular migration. And this is open to those who have been recognized as refugees and are looking to bring in their family members within this to Ireland within the state. So the main support that we assist with is travel assistance, travel tickets, necessary immigration formalities. We will not be assisting people with making the actual application that is required to be made at the Department of Justice. We are not involved in this process at all, but we do assist with travel tickets, visa waivers, booking flights at generally lower prices, provide IOM escorts for the travel if it involves young children or those with special needs, airport visits, coordinating with IOM offices, and assisting with obtaining travel documents. There are situations whereby someone will not be able to get a passport on time. We will be able to assist with obtaining necessary travel documentation. We are also involved in resettlement. We have a resettlement program, and IOM facilitates the humane and dignified travel arrangements for refugees who come to Ireland on a refugee resettlement program. So this is mainly for those coming into Ireland on a refugee resettlement program. We work closely with the Irish government, the United Nations High Commissioner for Refugees, non-governmental organizations, and other partners to ensure that people integrate and resettle well within the communities that they are allocated to. We also have counter trafficking, and this says it all. And counter trafficking, we work closely with victims of trafficking. It could be victims of trafficking. It could be sex trafficking or labor trafficking. And as you might already be aware, trafficking is also closely related with exploitation, sexual exploitation, and labor exploitation mainly. And in giving support to victims, we work closely with organizations such as Ruhama, the Immigrant Council of Ireland, just to mention a few, medical professionals, and the guards as well, in cases whereby the initial case needs to be investigated, but this will always be with the consent of the victim. We also have what is called the Protection for Vulnerable program. It's mainly for sexual and gender-based violent victims. So within this service, we do assist victims who are experiencing domestic violence, all forms of violence, including sexual harassment and violence, harmful practices, traditional harmful practices, exploitation, and trafficking as well. We also assist with integration, which I have already mentioned earlier, that we do assist with people who are coming into Ireland to resettle and integrate. We also work with migrants that are already residing in Ireland and assist them with integration. And we do this by linking them with the right professionals, linking them up with the right external service providers as well. And this brings me to the end of what we offer. And if you have any questions, please feel free to, please feel free. Any questions related to Dublin 3 regulation and the Section 3 letter notice to deportation will be taken by Dr. Ifer, and those related to IAM, I'm very happy to take them and my colleagues who are with me. Thank you.
I see a question from Abdullah. Thanks a lot for the information. If you've been granted a certain amount of years to live in Ireland, please, what happens at the end of your years granted, let's say at the end of 3 or 5 years? So it's really important to apply for a renewal of that permission before the end of the expiry date. So for periods of that length, in my experience, it's quite usual to be granted a renewal unless the person has some difficulty in terms of criminal law. But you know, all things going well or all things staying the same, normally a person with that length of time in the state would be granted a renewal of their permission. So the permission might be a stamp 4, which entitles that person to work. Stamp 2, if it's a student permission, there's a limited time frame for that. So 7 years of studying in state is the maximum. And then a stamp 1 permission, I don't think stamp 1 is for 3 or 5 years, but stamp 1 would be if a person has a work permit. So that would only really remain valid for the length of the work permit, and thereafter the person, if they wanted to continue to work, would really need to apply for a stamp 4. So I don't know whether that addresses the question asked. If it doesn't, please ask for clarification. Kuda, you're typing. Hello.
So yeah, there's a quite popular question that is always asked, and it's one of the questions that I always receive as well within the outreach team in the course of my work. And this question is within the length at which a deportation order stands once it is issued, and how long someone has to wait before they can return.
Okay. So that is an interesting question, because I know I worked in France before, and I know there they have certain time limits to their equivalent to a deportation order. Unfortunately, there was a challenge in Ireland to a deportation order because it is permanent. There is no end to a deportation order. They remain permanently in place, and there was a challenge to that in the courts, and that was unsuccessful. So it remains the case that a deportation order is permanent. The only way that a person can remove a deportation order is for them to apply to have it revoked. So they would have to apply to the minister to have the deportation order revoked, given grounds on which they, and normally the considerations would be similar to the Section 3 considerations when representations are made. But if it's not revoked, the deportation order excludes them from the state indefinitely. They need to apply for it to be revoked before applying for anything else they might need to get into the state, like a visa. So once it's revoked, it doesn't mean that they are entitled to enter the state. It just means that they're back to square one. They don't have a negative deportation order, but neither do they have a positive permission to enter the state. So they need whatever they need, a visa or a permission to enter.
Great. So this brings us to the follow-up question in terms of revocation itself. So if someone I'm actually trying to look at a very practical scenario of a question that I would be getting in terms of revocation as well. How would someone go about it? Like if they are outside the state, they are in a different state altogether. Does it mean they have to get family members to have it revoked, or they have to engage?
Well, a lot of applications these days can be made online. So, I mean, they can make the application online. They can set everything out, all of those considerations that I went through, set them out all in a detailed letter, scan supporting documents. It would be helpful to have either a family member or a solicitor in the state just to give them any updates in terms of the Irish law. But I mean, that would be how. The only difficulty is that sometimes these applications should be sent to the right division of the Minister for Justice. So there's a lot of different divisions. So that would just be something, make sure that the application is made to the correct division. And these are sometimes updated. So that would be important, because they could make the application online, and if it goes to the wrong division, they don't really have the power to process it. So, and they're quite busy, so it may not be passed on to the correct division. So that would be the one thing. Just make sure you're sending it to the correct email address.
Thank you.
Not at all. And thank you. I learned a lot today as well. And Rebecca.
Anyone with any questions for myself?
I'd just like to say thank you so much for hosting the session, Kuda, and also Aoife. I found it really informative, and I'm really looking forward to keeping my notes here beside me, and any potential slides, if we are sharing them, that would be great as well. Thank you so much.